appeal in the matter of Nokia Technologies and OnePlus Technology.
Yes, Mr. Lake.
My Lord, in this matter I appear with my own friend Mr. Daniel Alexander and Ms. Josephine Davies for the appellant defendants, which we'll refer to collectively as OPPO, and with the court's permission, Mr. Alexander and I would divide our submissions between the two of us, if we may.
Yes.
Thank you. And for the respondents, Mr. Nicholas Saunders appears with Ms. Joanne Box and Mr. Edmund Eustace. My Lord, may I deal with three short housekeeping points to begin with? Firstly, the parties would ask for an order in the usual form under Rule 31(22) to protect the confidentiality of documents which contain confidential information. The parties are agreed on what documents those should be, and I have a list of those which I can hand up, if that would be helpful. Secondly, my Lord, in the event that it becomes necessary to refer in oral submissions to matters which are confidential, we may have to ask the court to sit in private and to disconnect the live feed, but we'll deal with that if and when we come to it, and we'll try to keep any such private parts of the hearing, if they're permitted, as confined as possible. Thirdly, we prepared a note in response to the court's questions, which we forwarded electronically yesterday. We weren't sure whether or not the court wanted to have that in advance of the hearing. We have hard copies which we can hand up if the court would find that helpful.
Well, I have it in an electronic copy. Would you like it in hard copy?
No, it's fine, thank you. And it was very helpful. Thank you.
No, we're fine with what we've got.
So, Lord, the case is...
Before you embark, just one more housekeeping matter. Could you give us a map of the day, please?
Yes.
How are we going to divide it up?
I will be the first hour or maybe a little longer. Mr. Alexander will be perhaps the balance of the morning. We may or may not finish before that. Mr. Saunders will be in much of the afternoon, but he's kindly said he'll leave us enough time for reply. So I suspect we will be the whole day.
Very well. Well, we'll aim to sit until a quarter past, or if necessary, 4:30, but we won't sit beyond then. And you're confident that
well understood. Thank you.
We'll manage that.
Very well. Good. Lord, the case is about standard essential patents and about the terms on which their use is to be licensed in this country and around the world. The appeal, that's the case, the appeal is about the forum or fora that should decide the terms of the license. Now, I'm sure that the court will be well aware of the leading pair of cases on the topic in claims made by Unwired Planet and Conversant against Huawei and ZTE. We'll seek to explain this case is different from those in certain critical respects, decisive respects, we say. And it was the failure, we say, of the learned judge to appreciate those differences, or at least to give effect to the consequences of those differences, that gives rise to this appeal. Now, there is a problem.
But when you say appreciate, are you suggesting he didn't understand the point that you're making, or is your complaint really that he should have acted on it?
He accurately recited the provisions in Spiliada, but he placed undue reliance on the Court of Appeal decision in Unwired Planet, which was the appeal to the Supreme Court was dismissed, but on different grounds. As I
know I'm being pedantic, but it's not really, is it, a question of appreciation? It's a question of the weight given to the point.
Well, all I can say is, as far as the judgment is concerned, it doesn't take account of it, whether he appreciated it and left it out of account, or whether he really didn't take into account as a matter of staring into the learned judge's mind. But I don't claim to be able to do that. Now, the problem that lies at the heart of this was one that was identified by Mr. Justice Burse, as he then was in the Unwired Planet litigation, and which is now well known. It's been referred to in my Lord Justice Arnold's recent published paper on the piece, which on this topic, and it forms the subtext of this whole area, namely the tension between the local, limited, territorial nature of patents as local monopolies granted by individual states and the globalized nature of the businesses they serve. In this case, that's the mobile telecommunications industry, but the principles apply to numerous other sectors of industrial activity which rely on technology. One needs only to think of Wi-Fi, the Internet of Things, a whole panoply of modern life. Now, put at our simplest, we have two main submissions, and this is very much at high level. Firstly, the well-established principles of forum conveniens and forum non-conveniens apply to this case and should have led the learned judge to stay the proceedings against the English defendants in favour of the courts of China, and should have led him to set aside the service out of the jurisdiction on the Chinese defendants. We say this is a paradigm example of a case that fulfills the Spiliada criteria. If you don't stay the proceedings in favour of China in this case, it's hard to see any case involving the alleged infringement of British patents where the Spiliada would be applied. And we say it does apply and there's no reason to exclude it. Secondly, if the claim as a whole is not stayed in favour of China on Spiliada grounds, then a case management stay should be granted to enable sensible and proportionate dispute resolution in the appropriate fora, based on mutual respect for the processes of those fora, in other words, in a way that is consistent with the overriding objective and with comity. Now, we propose to structure our submissions under 6 heads, although there will inevitably be some thematic overlap between them. Firstly, the factual context. Secondly, the procedural context, both here and in other jurisdictions. Thirdly, the current state of English law on the forum issue. And fourthly, the application of the law on the forum issue in this case, including the ways in which we say the learned judge fell into error. Fifthly, our proposed solution on a case management stay. And sixthly, arbitration. I shall deal with the first 4 of those, and Mr. Alexander with the last 2. Now, Lord, I know that Lord Justice Arnold is very familiar with this area of the law. I wonder whether it would be helpful if I were just to outline for the record and for the others in court who may be less familiar with it, how the standard essential patents regime works. I can do it very briefly.
Please.
Standard essential patents are patents that protect pieces of technology which are claimed to be essential to the standards set by industry bodies for the mobile telecommunications industry in this case. So, for example, whether a mobile phone can receive 4G signal will depend on equipment for the transmission and the reception of that signal complying with certain technological standards. The industry body with which we are concerned is the European Telecommunications Standards Institute. It's a voluntary industry body. Now, whether the technology is essential to the standard is, at least in the first instance, determined by way of an assertion by the patentee who claims that it's essential. He makes a declaration to that effect to ETSI, and it's not independently assessed or verified by ETSI. If they don't make such a declaration, I understand that the likelihood is that a particular piece of technology will not form part of the standard.
It's not just a likelihood, it's an inevitability, because the way the standard system works is that technology subject to what are those dates always pending patent applications will not be incorporated unless firstly there's a declaration of essentiality and secondly a FRAND undertaking.
I'm very grateful.
That's the way the system works.
Well, the position is explained in outline, at least, in the Supreme Court decision in Unwired Planet, at paragraphs 5 to 15. I just refer you briefly to a very short passage in that, if I may, which is at the second authorities bundle, behind tab 31, if you have it in hard copy, and starting at page 986 of the bundle. At the very bottom of the page, below J, when considering whether
the electronic page.
Electronic page 986, my lord. The bundle of the page of the report is 1148.
just for future reference, if you divide up the authorities electronically into 3 bundles, then one doesn't get the electronic bundle number automatically. So we'll get there, but you say 986 is the passage you want to refer to.
I think the numbers, the pagination runs throughout the 3 of them. Yes.
It does, but it doesn't electronically. We have an electronic number at the bottom of the page, which represents the page in the bundle we're looking at.
Well, that's a lesson that I'm sure those behind me will learn for the future.
Right. Well,
behind tab 31,
at least some standard setting organisations.
When considering whether to include a technology in a standard, ETSI requires the patent owner to enter into an irrevocable undertaking or contract with it to allow implementers of the standard to obtain a license to use the relevant patented technology on fair, reasonable and non-discriminatory terms. FRAND is the term we use. If the declared patent invention is included in the standard, and it's not possible to make, sell, use or operate, etc., equipment or methods which comply with the standard without infringing that IPR, it is treated as an essential IPR. The irrevocable undertaking to give a license on FRAND terms to implementers applies to any such essential IPR, but ETSI is not under an obligation to check whether patents declared to be essential are in fact essential, nor does ETSI make any binding judgment on the validity or status of such patents. ETSI Guide on IPRs of 2013, paragraph 3.2.1. Those are matters for the relevant national courts. ETSI leaves it to the relevant parties, if they so wish, to resolve those questions by court proceedings or alternative dispute resolution. It points to the guidance. So that's the outline of how it works, Lord. What the ETSI documents do not do is further define what is FRAND. Mr. Justice Burse held in the first instance decision in Unwired Planet that only one set of terms could be FRAND. The phrase one true FRAND has been used, at least colloquially, to refer to that point of view. But that proposition was overruled by the Court of Appeal, and it is now settled that different sets of license terms can each be FRAND, which includes different rates of remuneration.
There's a range.
Yeah. A range not only in terms of monetary compensation, which of course is the most the thing of greatest interest, but also other terms can vary between different forms of FRAND. Lord, turning then to the first part of our submissions, by way of factual background, until a year ago today, the 30th of June 2021, Nokia and Oppo had a license which included a cross-license for Nokia's use of Oppo's patents. The parties had been negotiating for some 18 months for a renewal of that license since January 2020, and Nokia had sought terms, details of which are in the confidential evidence, but which were not acceptable to Oppo. We've identified this in confidential paragraph 12 of our document. I'm not proposing to read it out at this stage for obvious reasons, but you can see what Nokia says about that in paragraph 5 of their skeleton, and our answer to their propositions in outline is to say that their explanation relates to the past and not to the future use of Nokia's patents, and you can see there how they seek to answer the point. We say that it doesn't amount to a sufficient answer. Now, Oppo started Chinese proceedings. The first thing that happened was that the day after it expired, on the 1st of July 2021, Nokia, without prior warning, started proceedings in a number of countries, including this one, and these proceedings started on the 1st of July.
Yes, one small question on that. The parties have provided a very helpful chronology for which I'm grateful, but one date which is missing is the date of service on the English defendants.
My Lord, we'll provide you with that. There was an issue about that, which was resolved at the first instance, to the effect that our acknowledgement of service was out of time. That, Mr. Justice.
Yeah, but that's, as you say, about acknowledgement of service, not about date of service.
Yes, so there was
actually, however, I think that gives me the answer, because the judge says he says the particulars of claim was served on the 6th of July. Oh no, I see. The date is in paragraph 1 through 1. I found it now. 2nd of July is what he says, so I assume that's accurate.
Question upon whom it was served. and whether or not...
Yeah, I'm just talking about the UK defendants, not the Chinese defendants. They accepted service in September.
Just on that point, my lord, we should of course point out that of course we've got the two or three UK defendants. There are 7 defendants altogether. The one that matters, if I may say so, is the third defendant, at least so far as FRAND terms are concerned, although obviously not in terms of alleged infringement, because the third defendant was the party to outgoing license agreements on behalf of all the other parties and was negotiating for a new FRAND license on behalf of all the other parties. It's a Chinese company. Oppo started...
On that question, can you help me on this question? It may be that it's a matter in dispute, I don't know. But does the third defendant carry out any acts within the United Kingdom, or is it only the English defendants who carry out acts within the UK?
Lord, I'll take instructions on that. I'd be reluctant on record to give you an answer where I'm not confident of the answer myself.
Fair enough.
My Lord, I've been handed a note that the claim form was deemed to have been served on the 6th of July.
Okay.
Now, as I say, Oppo started Chinese proceedings, both for the setting of global FRAND terms and complaining that Nokia had acted in breach of its FRAND obligations in the manner of its negotiation for the new license. And I'll take you to at least the first of those in a little more detail in a moment. And then moving on to the second of my headings on the procedural background, there are 3 parts to this: the United Kingdom proceedings, the Chinese proceedings, and elsewhere. Nokia started proceedings against the 7 defendants. 2 were English companies, served as of right in this jurisdiction, and 5 were Chinese companies, served with the permission of the court. Technically, this means that our application is for a stay of proceedings against the English companies on the grounds of forum non-conveniens, and to set aside the permission to serve out on the Chinese defendants. In substance, as I said a moment ago, it's a dispute with the third defendant who was the negotiating party and the party acting on behalf of the others. We say, in respect of both the defendants and as far as relevant, both the third defendant and the other defendants, that Nokia has not shown that England is the proper place to bring the claims and that their own judge was wrong to hold the contrary. Now, I invite you to look at what Nokia is claiming. Initially, they advanced a narrowly formulated claim, simply seeking endorsement as FRAND of their various offers, as well as seeking declarations of essentiality, validity and infringement of their 3 UK patents covering 4G technology, which they asserted in the proceedings. Subsequently and recently, they have applied, indicated I think back in May, and have now applied to amend their claim to do 2 things. Firstly, to ask the court either to endorse their offers as FRAND or to determine what terms would be FRAND, as happened in Unwired Planet, and to argue that unless Oppo undertake to enter into a license set or endorsed by the English court to be FRAND, a declaration that it is not a party protected by the FT undertaking. And perhaps I could just show you that. It's in core bundle at tab 18. And perhaps one can most conveniently...
Just before we get into detail, can you update me on the status of the application to make these amendments?
It's pending, my lord, and has not yet had evidence served in reply.
So I take it, therefore, that you're resisting?
Well, I'll tell you our position on it.
Yeah,
We served, when it was sent to us in draft, we sent a request for further information, which was partly answered by Nokia. We are not satisfied that they've given us sufficient answers, and we remain to resolve that issue. Our position on this appeal, my lord, without prejudice to any particular arguments we may make on amendment, is we're content for this court to proceed on the basis that the claim will be in its amended form.
Thank you.
And we're turning then to the draft amended particulars of claim at tab 18. They're in core bundle 221, but I can perhaps most conveniently go straight to the prayer for relief, which is at page 230, internal pagination, page 10. You can see that originally they claimed declaration of essentiality and declarations of validity and infringement, and a declaration that the terms of the Nokia offers were FRAND, and claimed that they, insofar as the defendants in each of them are entitled to take a license to the patent on FRAND terms, in accordance with the declarations in the ETSI policy, insofar as the claimants are and remain required to grant such a FRAND license, a FRAND injunction to restrain the defendants from infringing the patent. Your lordships will no doubt be aware of what a FRAND injunction is. It was a term coined by Mr. Justice Bursey in On Wild Planet to mean an injunction restraining infringement unless and until the implementer entered into a license on the terms set by the English court. And the terms set by the English court were for global licenses, licensing not only the use of the UK patents in the UK, but all the other patents in the portfolio, in the same families at least, around the world, setting global rates. And that's the thing that's the critical feature of these cases, is that rather than having country by country patent infringement determination, or patent licensing determination rather, the revolutionary step taken in One Eye Planet was to declare that the use of UK patents would be barred unless a party entered into global terms set by the English court.
Leaving aside the jurisdictional dispute, am I right in understanding that in the present case it is common ground that FRAND terms will be global?
Yes, my lord.
Thank you.
As I said at the outset, the critical question is, on this appeal, is which court or courts get to set those terms, or which forum or fora get to set those terms. Now, the amended form of the claim, yes, one of the features of Mr. Justice Bursey's licence, as Mr. Alexander reminds me, is that it contained within it a clause permitting the implementers to make applications to local courts to have local terms set varying from the global terms set by the English court. So an adjustment clause for regional differences. So the global terms were the default, but it was up to implementers to seek to apply elsewhere if they wished to have regional variations. And indeed, and there were different categories of rates at least set for different markets, and in particular a different rate was set for China. From recollection, I think there were major markets, minor markets, and China are three different categories of rates being set. The amendments we can see on page 230 are that they now say, in addition to declarations of essentiality, validity and infringement, that insofar as the defendants, each of them, agree by undertaking to the court to take a license to the patents on the terms determined by the court to be FRAND, a declaration that the terms of the Nokia offers are FRAND, alternatively, a determination of the FRAND terms for the licensing of the patents and a declaration that such terms are FRAND, and save insofar as the defendants undertake to the court to take a license of the patents on the terms determined by the court to be FRAND, a declaration that they don't fall within the class of beneficiaries of clause 6.1 of the ETSI policy. That is to say, the persons for whom the undertaking by the patentee is, for the benefit of whom the undertaking by the patentee is given to ETSI. So effectively, an undertaking for the benefit of the third party, ETSI being the recipient of the undertaking on behalf of the implementers, although the precise legal analysis was something that was closely examined by Mr. Justice Burse, and whether it was contractual or not as a matter of French law was a matter of some controversy in that case. It doesn't matter because nobody is suggesting that it doesn't bite on the implementers in this case. Now, there are a number of points here which are not for determination today. One of them is that the undertaking is to the court. We have given a contractual undertaking to Nokia to enter into a global license on terms set by the court that we contend is appropriate, namely the Chongqing court in China. But they are saying that only a declaration to this court will suffice. That is the subject of another case called Optis and Apple, where Mr. Justice Mead, in a case where I think the jurisdictional issues were a bit different, said that an injunction was to be granted at the outset before the court came to determine the issues in the case as to the FRAND terms, to enter into whatever license the English court should ultimately hit upon in order to avoid an interim injunction being imposed. Now, that decision is itself the subject of an appeal which will come before this court, I understand, in October. So that's the first point. The second point is that the scope of the class of beneficiaries is in dispute. But the Optis and Apple point, as it's being referred to, is the question of whether or not an undertaking to the English court is to take terms set by the English court is the only thing that will avoid an injunction in the event of there being infringement. Well, may I just come back to the question raised by my Lord Justice Arnold, asking whether or not the third defendant carries out acts in the United Kingdom? No. There is a dispute about this. The third defendant denies that it acts in the United Kingdom. This is set out in its defence at paragraph 10, B, D, and E in respect of the different defendants. And that's at core bundle pages 184 to 185. Defendant admits joint liability with the fourth defendant. It denies any act in the United Kingdom. And that's paragraph 10, little I, core bundle page 186. So, my Lord, you can see the way in which the claim has altered over the course of the proceedings so far. Now, one of the peculiarities of this case, at least peculiarities to those who are not so familiar with the practice of the Patents Court, is that notwithstanding this jurisdiction dispute, the proceedings are going ahead, albeit in draft, without prejudice to the outcome of the jurisdiction applications and this appeal. Now, this has led to the current state of play in the underlying proceedings, which is that 5 trials have been fixed for periods between November this year and October next year.
Yes, can I ask you a question about that? Because you tell us in paragraph 7, you'll give us an argument that this is a continuation license case. Both parties want a new version of the existing license. In paragraph 19, you say the dispute is not about whether OPPO will take a global license, it's about the terms of that license. In paragraph 48, you say that OPPO accepts that it needs a global license for the portfolio taken as a whole and undertakes to take one. Paragraph 51, you say OPPO want and will take a global license. It follows, does it not, that there is no need at all for any technical trials of patent and validity and essentiality and infringement in this jurisdiction, and we can proceed straight to FRAND.
I understand your Lordship's point, and we would prefer not to have to do technical trials because we say...
It's your choice. You don't...
No, that's right, of course it is, and I say it with all respect. But they've made assertions of essentiality, validity and infringement of patents that we do not accept are essential, valid or infringed. I emphasise that essentiality is a matter of party declaration. And we should not have to be put in a position where we simply have to accept the essentiality of patents which has been merely unilaterally declared by one party. So the defendant companies say that it will be irrelevant if and when we get to a global license, because the entire portfolio will be licensed.
So why is your client's position not one of cakeism? It wants to have its cake and eat it. It wants, on the one hand, to tell this court, when it comes to jurisdiction, that this is only about the terms of a global license, and yet when push comes to shove and the proposition is put to you, well, you can have a FRAND determination straight away, you say, oh, no, we've got to have 3 5-day trials of patent infringement, validity and essentiality.
Well, that's why we're making this application for the proceedings to be stayed pending the setting of a license by the appropriate forum, which would then mean that the technical trials would not have to go ahead and would ultimately never be necessary.
But why are there technical trials if this is a continuation?
Well, my lord, because it raises a different question. It raises an assertion of essentiality and validity and infringement of patents.
I thought you were just seeking to continue to use this technology on fair terms.
Well, there may be knock-on effects, of course, but the license covers not only essential patents but non-essential patents, unless I'm correct.
Now, all of this is repetitively circular, because arguments that you make about the fact that it's very undesirable that all this expense and time should be taken up not once but twice, of course, is the consequence of your having sued second.
Well, you could put
Similarly,
it
you can say you can yourself say it's a consequence of them having sued first. Forget who sued first and who sued second. It inevitably just goes round and round and round.
Who's first and who's second, my lord, since we've escaped from the Brussels regime, is not of itself a material concern.
No, it's not decisive.
But the allegation, or the charge of cakeism levelled at my clients should, with respect, be levelled at Nokia, who seek to have the validity of individual patents asserted when they don't need that to get a global license. And it's because the determination of FRAND, by reason of the procedure of this court, it arises as a defence to a claim for an injunction, that we're concerned with the essentiality at all. It's because of the way English courts go about it. Interestingly enough, the Chinese court does not have that constraint. It will decouple the question of license terms from questions of infringement and validity. It's only because our chancery procedure links, or at least the procedure that the claimants have chosen to adopt, links determination of FRAND to allegations of validity and infringement, that we're here at all on those issues. And they probably have to do it in order to get themselves a jurisdictional gateway, because any other, a claim generally for declarations might possibly run into jurisdictional difficulties, because they might not find a sufficiently close connection with the United Kingdom to justify a claim for a global license. And so what they've sought to do is to choose a small offshore forum, with no disrespect to the United Kingdom, it represents less than half, or about half of 1% of global sales that we're talking about here, in order to seek to get terms set for the global licensing. And we say those terms should be set in a jurisdiction that does not link the license terms to questions of validity or infringement, because they will become irrelevant, and because it's the appropriate forum by virtue of all those other things, such as the size of the market share.
But you acknowledged earlier that the underlying problem is that patents are territorial, they're local monopolies. So where else do you enforce a patent other than in the local court?
Well, of course, you have to enforce the patent there if enforcement of it comes into issue. But the whole point about this global license is to avoid having to do that.
Yeah.
So, my lord, I appreciate the point that we may be faced with what, in all likelihood, will turn out to be an OTS exercise. But to lay the blame for that at the door of the defendants disputing validity, in our submission, is not the right approach. The right approach is to see this is the procedure that Nokia have chosen to try to get this court, to leverage this court into, or leverage us into facing the determination of license terms in this court. And I come back to my Spiliada point I made at the outset. If the approach adopted by Judge Hacon in this case is right. There will be no case involving the implementation of the UK patent which can be determined as to its license terms in a forum, however otherwise appropriate, for setting of global terms. And we say, the one thing that is said extrajudicially about this is that an internationally acceptable solution must be found to what is undoubtedly a problem. And we say that the circumstance that arose, unwired planet, no jurisdiction dispute arose. Conversant followed it and they got to the Supreme Court together. But that was at a time when the Chinese courts would not set global terms. There was no other available forum. There is now another alternative forum. The Chinese have changed or adopted by reference, including the reference to the UK Supreme Court, and they've taken it into account. They've adopted the same approach of setting global patents. Difference being they don't link it to infringement. And so we say that that's changed the landscape and an internationally acceptable way forward can be found. We say the circumstances of this particular case, which I'll go to in more detail in a moment, should lead the court to the conclusion that these proceedings should be stayed in their entirety, and I say stayed rather than dismissed at this stage, because if any question of essentiality or infringement were to arise at a later stage, and I take Justice Arnold's point that's most unlikely, but if it were to arise at a later stage, it could then be reasserted once global terms are set. And so, but we say that the appropriate forum for the determination of global terms is the forum that represents the vast bulk of patent-protected activity by these patents. Now, I'll develop that in a little more detail when we come to it. I've identified the 5 trials. In addition to the 3 technical trials, there's the trial of the question that arose in Optus and Apple about whether or not an injunction is to lie before determination of global terms here, unless the party gives an undertaking to enter into the terms set by the English court. And that's the one that's due for appeal in the other case in October. And then there is the prospect of a trial to determine the terms of a FRAND license, which is set for October 2023. So this is the current state of play in the UK proceedings. We say that it's a waste of time and money entertaining those proceedings here if the global license is determined in the appropriate form. Now, turning, if I may, next to the Chinese proceedings, Oppo started the rate-setting proceedings in July 2021. The big difference, which I've outlined briefly as compared with Unwired Planet, is that it's now clear beyond argument that the Chinese courts can, even without the consent of both parties, determine what terms are FRAND for the licensing of global patent portfolios. It's the effect of the decision of the Supreme People's Court of the People's Republic of China in a case brought by Oppo, as it happens, against Sharp. And I invite your lordships to look at that. It's at tab 39 in the authorities bundle, which I have in bundle 3. I'm told, hopefully, that the internal number within bundle 3 is 267. The number appearing on the pages is 1336. And I'm just going to take you through a little bit of this, not at, I hope undue length, in order to show what the Chinese court has done. This is an official translation. On internal page number 2, and the numbers are in very small at the bottom left-hand side of the pages. So page number 2 at the bottom, it's an appeal to the Supreme People's Court by Sharp, and it's asked the court to do a number of things. Secondly, to make a ruling dismissing the complaint filed by Oppo and Oppo Shenzhen regarding damages for infringement, ruling on the global licensing conditions for Wi-Fi SEP, and ruling on the licensing conditions for 3G and 4G SEPs outside mainland China in accordance with the law if the above requests fail to be fully met. At the top of the next page, there's the beginning of a laying out of the facts and grounds. And if you then go to page 5, you see the beginning of a recital of a number of the arguments addressed by Oppo. Then the fourth of those, at the top of page 6, says this: the Chinese court shall be entitled to make a ruling on the global licensing conditions for the SEPs in question. Typo. 1. The SEPs are distributed globally, and thus there is factual basis for the Chinese courts to make a ruling on the global licensing conditions. China is the place most closely related to this case, thus the Chinese court is the forum conveniens. Interesting they use the Latin phrase adopted from Scottish law originally. Sharp has proposed an offer for license based on global licensing conditions after initiating a licensing negotiation with Oppo, showing the parties concerned are willing to reach an agreement on the global licensing of the SEPs in question. Even if the parties concerned fail to reach an agreement on the jurisdiction, the UK Supreme Court made a final judgment on the 26th of August 2020, affirming that the UK court has jurisdiction over the global licensing conditions for the SEPs in question. The filing of claims for ruling on the global licensing conditions does not violate any prohibited laws of China, and the laws and judicial policies of China have never clearly denied the jurisdiction of the Chinese court over the global royalty rate of the SEPs. Therefore, the ruling on global royalty rate is legally based and objectively needed for solving the licensing dispute once and for all. And then one goes over to page 8, where you get the court's determination. Upon examination, the court preliminarily ascertained, and then it sets out one fact, and then at 2 it starts basic information on overseas raised lawsuits, and then over at the top of 11 there's a heading whether the Chinese court has jurisdiction over the case, and picking it up 5 lines down, whether the SEP licensing dispute is properly related to China should be considered based on the characteristics of such dispute. It can be seen from the judicial practice that such dispute has not only some characteristics of contract dispute, for example, the dispute over some agreements on the licensing conditions, including royalty rate between the parties, may need to be determined in accordance with the negotiation process, but also some characteristics of patent infringement dispute. For example, it may be necessary to judge whether a patent as the subject matter of the license is a SEP, or whether the standard implementer has invented such patent, whether such patent is valid. However, the core of the SEP licensing dispute is requesting the court to determine specific licensing conditions or contents, and thus making the parties reach or perform the licensing agreement. Therefore, the SEP licensing dispute can be deemed as a special dispute with more characteristics of contract. Comprehensively considering the above characteristics of such dispute, as the defendants are foreign enterprises without domiciled representative office in China, the following question can be considered in judging whether such dispute is properly related to China. So the place of patent granting, place of patent implementation, place of signing of the patent license contract, or the place of patent license negotiation, place of performing patent license contract, location of the property available for seizure or enforcement is in China. This case should be deemed to be properly related to China if any of the aforementioned places is in China. The Chinese court shall have jurisdiction over this case. And just interpose, it looks a bit like our Part 60 gateways. Carrying on, in this case, the SEP portfolio as the subject matter of the license involves many Chinese patents. Oppo and Oppo Shenzhen have implemented the SEPs in question in the manufacturing activities carried out in China, and the parties concerned have negotiated with each other about the licensing of the SEPs in question in Shenzhen. Therefore, the Chinese court has jurisdiction over this case in accordance with law. And then they go on to consider whether it's appropriate for the court of first instance to exercise jurisdiction over this case, and conclude that it is. And then over the page at 13, heading 3, where it's appropriate for the court of first instance to rule on the global licensing conditions for the SEPs in question in this case. In this case, Oppo and Oppo Shenzhen filed a lawsuit in the court of first instance, requesting it to make judgment on the conditions for licensing Wi-Fi 3G and 4G SEPs that Sharp Corporation owns and has the right to license globally to the smart terminal product of Oppo and Oppo Shenzhen, including but not limited to royalty rates. On review, the claim conforms to the provisions of the law, regarding the conditions of the complaint does not fall under circumstances of refusal to accept as set forth in a civil procedure law. Sharp and Science Visit Japan requested to make a ruling dismissing the complaint filed by OPPO regarding damages for infringement, ruling on the global licensing conditions, and so forth. Opposite the lower hole punch, whether it's appropriate for the court of first instance to rule on the global licensing conditions for the steps in question in this case should be comprehensively considered based on the particularity of set licensing dispute and the basic fact about jurisdictional dispute in this case ascertained. And then they set out their views on those questions in numbered paragraphs on the next 2 pages. I think that's probably all I need to take the court to, unless anybody wants me to go any further. In summary, we say what this shows is the Chinese courts have the power to determine terms and rates for patent licensing, not only for Chinese patents but also for those outside mainland China. Indeed, the Chinese court, having referred to the Huawei decision, said, well, actually, we've never said we won't, and now they're saying they will. Secondly, the Chinese court will consider the particular circumstances of the case in order to determine the appropriateness of Chinese courts exercising the jurisdiction, and it will examine the whole dispute in characterizing it in order to identify all relevant connecting factors. So far as our particular Chinese proceedings are concerned, in this case, they are in the supplemental bundle at tab 12. I probably don't need to take you to them. They're a claim for a declaration of FRAND terms. The term rate setting claim has been used to describe these proceedings, but they're not only for setting a rate, they're for setting FRAND terms. They go a little wider than just questions of rates. I just refer to passages of evidence which you've no doubt read, but I will, for the purpose of our note, I'll give it to you, unless you wish me to take you to it. In Lao 2, which is at Supplementary Bundle tab 11, at paragraph 7a, she makes the point that a rate-setting claim can be brought independently of an infringement action. In Liao 1 at tab 10, at paragraph 16, she makes the point that in setting a rate, the court will undertake a valuation exercise. And at paragraph 21, A and B, she refers to the methodology that would be used in a Chinese rate evaluation, and says that the Chinese court would have regard to the different market conditions in different markets. In Liao 3 at tab 18, at paragraph 11, she gives an update on timing. Her view was that the jurisdiction judgment would have been handed down by about now. That hasn't actually happened yet, and that because Nokia have challenged the jurisdiction of the particular Chinese court, saying it should be heard in Beijing rather than Chongqing. But that if the appeal against the assertion of jurisdiction in Chongqing is dismissed, a FRAND judgment could be heard sometime towards the latter part of this year. The claimant's evidence in response, which we say goes rather wider than being strictly responsive, asserts that there's uncertainty about what the Chinese court will do, but we would say that once the Chinese court has ruled, the parties would be able to consider what that ruling is, and if necessary come back to the English court to review the terms on which any UK or EU licenses patents are to be licensed. He also asserts that a rather longer timescale is to be expected.
Can I ask you, just basic approach to jurisdiction cases and forum non-convenience. The first thing that seems to me that has to be done is you have to identify what the issues are in the proceedings. And you very beguilingly say, well, it's all about FRAND. But that's not the way that we approach what are the issues in the case. We look at the pleadings, what the claim is, and there's no doubt here that first and foremost, these are claims in relation to establish validity infringement. And those aren't illusory or non-real issues because you are contesting them.
Well,
To the extent that can I just ask the question? You're contesting them. So why, as a matter of jurisdiction and forum non-convenience, do we not have to look at where those issues are best determined?
Because those issues might never, in all likelihood, will never need to be determined.
Well, that might arise on case management. But as far as the approach of the court to forum non-convenience, on what basis should one be staying claims properly brought in this jurisdiction, including against UK defendants, which, as you say, are going to require several trials on a forum non-convenience base, when it seems to me those matters are plainly best tried here.
May I give an analogy by way of response, my lord? The practice of the commercial court for many years has been, perhaps more firmly in years gone by than it is now, to stay the proceedings before it for a short period, however much a trial might otherwise be inevitable, in order to enable the parties to enter into mediation. And they used to refer them to CEDAW or elsewhere for alternative dispute resolution and not permit the proceedings to go ahead while that process is completed. We say this is analogous because ultimately the trials...
That's case management. That's case management. That's not jurisdiction.
I'm not seeking to say it's not the right approach, and indeed on case management it is our approach. What we say is that our primary argument is that you should stay the whole proceedings, including the technical trials and so forth. It may be that ultimately the two questions come down to the same thing, because I'm not saying that the proceedings against the English party should be dismissed out of hand. What I'm saying is they should be stayed.
But you are, but effectively you are, because once they're stayed on forum non-convenience grounds, they will not be proceeded with, and no part of them will be proceeded with.
No, but that, with respect, is usually the case. I grant you that, but perfectly plain that proceedings stayed on forum non-convenience grounds can be revived. I mean,
Well, they can, but what one doesn't do in the commercial court or
number one.
elsewhere is to pick off bits of a claim and say, well although you look at the claim overall and say, where is this claim most appropriately tried?
Yes.
You don't say, well, yes, we accept that validity and infringement are appropriately tried here, but we're going to stay all that while we go and try another bit, which wouldn't even arise if Nokia don't establish validity and infringement.
Well, I entirely accept the force of that point for the purpose of our case management stay. I say
and also for forum.
Well, we say for forum, there really is no need to be going ahead with technical trials until...
Where does that come into? I'm sorry, I don't understand how, but we seem to have lost touch with the basic approach to jurisdictional disputes here. We don't talk about it in those terms. We look at what are the issues and where given all those issues all together, this claim is best tried. And it seems to me there is nowhere else that the validity and infringement issues can be tried but here.
Yes, but our point is, as I hope I'm repeating myself, is they probably won't need to be tried.
Sorry, I don't understand that. Only they wouldn't have to be. As Lord Justice Arnold put to you, you could remove that by saying, well, we don't contest those issues.
Oh.
But you don't. You haven't. You are, as I understand it, proposing that we're going to have 5 issues. And it seems to me that the main effect of that is to enable you to say, oh well, by the time we dealt with all that, the PRC courts will have determined the FRAND issue, which means that you're generating for yourself the delay, and the PRC court will be first in time by the stance you're taking here on issues which you say don't need to be determined.
Well, I'm not sure it would have that effect because by the time trial E has been undertaken and the FRAND trial has been undertaken, the expectation is that the Chinese court would reach a conclusion on that in any event. So we would end up with 2 different FRAND rulings. And at that point, Optus and Apple point.
Well, only if you choose to pursue parallel proceedings in China, rather than dealing with the FRAND issue in the context of the jurisdiction which is founded here in relation to UK patents determining issues of validity and infringement which are properly determined here. It's your choice if you choose to run parallel proceedings.
May I invite your Lordship just to reflect on the way in which you put that, as if somehow there was some capricious choice of China, so where we choose to proceed. This is a Chinese case. This is overwhelmingly a Chinese case. And it's only because Nokia have chosen, I don't want to use the term offensively, but conversely have chosen a forum that is prepared to offer this, but is in other ways not appropriate for the determination of the meat of the issue between the parties. The meat of the issue is not the validity or essentiality. The meat of the issue is the FRAND licensing.
Well, are there any Chinese patents involved?
There are Chinese patents involved, but they're not essential to there are large numbers, far more Chinese patents involved, both in terms of numbers of patents and value than there are. These are 3 little 4G patents. They're not even putting in issue the 5G patents that they say justifies their
Why don't you just accept that the claims for validity and
my instructions are clear that we do not wish to accept the validity.
Well, that means that the issues in this action are live and real and properly determined here. And I think you can't, my lord, or just as Arnold puts it, you can't have your cake and eat it. It seems to me that's exactly what you're doing.
Well, that's what Nokia
on the basis of your instructions.
My lord, if it's necessary, but that is precisely why we're here, to say that these proceedings should be stayed. If you deny a forum non-convenience stay, or deny a case management stay, then we go ahead with the technical trials in circumstances where global rates will be set in China, and we then get into the tussle that arises on the Optus and Apple issue about whether or not we would be forced to accept this lot of FRAND terms rather than that lot of FRAND terms. I do emphasise, and there's no issue about this, that the Chinese court will set terms that both parties accept would be FRAND within the range, capable of producing terms to that effect. Mr. Justice Henry Carr said so at the first stage in Conversant, and there's never been any really doubt about that. So what you're faced with is global terms set by much the largest market, and global terms set by a market where the monopoly being protected is of 3 4G patents where the parties had covered by an outgoing license in any event. They're not put in issue patents for which they claim an uplift as compared with the previous license in any event in this jurisdiction. And we say that
enlighten us to the relevance of that. Is it your suggestion that Nokia should have ensued on their entire portfolio?
No, I'm not saying that, my lord, because
they've chosen 3 out of the portfolio.
Yes.
What does it matter whether they happen to have chosen 3 4G or whether they chose 3 5G? Why would it make any difference?
Well, it won't make any difference if the court is prepared to consider the entire portfolio for the purpose of global and FRAND licensing.
Which, of course, it will do.
Of course,
it will do, inevitably. Whether FRAND terms are considered by this court or by the Chongqing court, inevitably it's going to be on a portfolio basis.
Of course. So it is no more, and it exposes exactly the truth of what's happening here. It is no more than a hook upon which to claim global FRAND licensing. That's what the relevance of those 3 patents is. It's a mere jurisdictional hook, which has consequences of 3 unnecessary technical trials. But it is a jurisdictional hook.
It's a pretty firm anchor, isn't it?
For the purposes of arguing about those 3 patents, yes. Which we probably don't need to do.
I just don't understand how you can say that those claims should be on a forum basis, are not properly tried here, and we're quite used in the jurisdiction field to talk about anchors.
My lord,
and anchors work.
May I make the point? I'm not contending that the validity, essentiality, or infringement of GB patents should be tried anywhere other than England. What I'm not saying is, so that's maybe a distinction with the classic Spiliada case. I'm not contending that there's another forum suitable for that. What I'm saying is that there's another forum suitable for the determination of the real dispute between the parties. and that if ultimately the FRAND issues are staying here, and we have to go ahead with our technical trials because this is the appropriate forum for them and nobody's going to stay those, well, that's probably a waste of time and money, and court time and court resources, but it could be done. The alternative is actually to say, no, we'll stay those technical trials along with everything else until we've got an answer to the real dispute between the parties. And then we probably won't need those technical trials at all and won't use up the court's resources and the parties' time and money. That's what I'm saying.
It's entirely our fault, but we've rather moved you off the procedural background. Is there anything more you wanted to say?
I've more or less completed what I was going to say. So far as the other proceedings are concerned, in a raft of other countries, we've set them out in Annex A to the note, and I hope that you will allow me merely to incorporate answers to the questions.
Yes, that's very helpful, and I'm grateful for the effort that's been put into that. Can I just ask, though, with regard to this question, let's assume your appeal is successful and there is a stay either on forum non-convening grounds or case management grounds. Obviously, that won't affect all the parallel cases proceeding in other jurisdictions. So what then happens?
Lord, may I? We've got a good answer to that question, which I'm hoping Mr. Alexander will address you on when it comes to the case management. If your Lordship will exercise a little forbearance, we can come to it when he comes to it.
Fine, I'm happy for him to do it.
So, my Lord, as far as those other proceedings are concerned, I don't think that there may or may not be anything controversial about it. Mr. Saunders has asked me to apologise on his behalf to the court for his having not picked up the questions initially, with the result that Nokia have not been as far ahead of the game as we were in trying to get detailed instructions on those proceedings, because there was a mistake in his email address from the court, and his junior identified in that email is no longer instructed, but he will be able to deal with it.
I'm sorry on the court's part that mistake was made.
I'm hoping it'll ultimately make no difference.
My Lords, I can just address that very briefly. We are hoping that we can provide a very brief markup to the annex that my learned friends have put in. It does entail calling around to lots of different jurisdictions that are in the process of doing that, but
sure.
We hope to have that with you today.
That would be very helpful, thank you.
Right, well, then I move on to Part C. I've taken rather longer on Parts A and B than I expected, but it's covered some of the ground anyway. The current state of English law on the forum issue, the court's undoubtedly familiar with the principles to be applied in either assuming jurisdiction over a foreign defendant or in staying proceedings against the defendant duly served within the jurisdiction. The headline points are that the case must be considered as a whole to determine the most appropriate forum. Lord Justice Phillips has identified as the issues, but unlike some other areas of conflict of laws, you don't separate out the issues, you look at the case as a whole.
I thought my Lord was saying one starts with looking at the issues, and pleadings are generally the best guide to those.
Of course.
I wasn't understanding, but he'll correct me, that he was
I suppose my point
saying it's only about the issues.
If I can cut to the core of it, is this, that the fact that it's a patent infringement case of a GB patent is not or should not be regarded as a trump card. Because that is only one of the issues in the case when you judge the case as a whole. And it's for the determination of the dispute. And the dispute here is about licensing terms. Now, we say the case meets the relevant criteria. If you don't set aside in this case, we ask, when would you ever apply the Spiliada criteria to a patent infringement case? This is as paradigm a case as one can imagine. And I'll explain in a moment why that is. Now, the Spiliada principles lie at the heart of the appeal on this aspect, and I will welcome the court's guidance on this point. I'm sure the court is familiar and has many times read the Spiliada judgment, and I'm content not to go through it, although it represents the law in this area, and it's often helpful just to reread it. Indeed, I think Lord Griffiths in that case recommended that the judge read the judgment in the quiet of his room before...
And it should only take 20 minutes. the whole thing.
But I can do it much faster than that, if it's helpful.
The whole
No,
jurisdiction.
the dispute.
The whole jurisdiction dispute.
I don't get any dispute about it. The fundamental principle is there, as stated in Sim and Robineau. Draw your attention to that. It's pages 55 to 64 of the appeal cases. It's the treatment of a legitimate personal or juridical advantage, and that has some bearing here, and the interest of all the parties. Lord Gough, of course, picks up the point I think made by Lord Wilberforce in the Aberdeen-Dava that what is an advantage for one party is a corresponding disadvantage for another party, and the court has to strike a balance over that. So if you say, well, if rates are set in China, they'll be lower than they are in the United Kingdom, so that may be a disadvantage to a patentee. And of course here we're concerned with cross-licenses, so it cuts both ways. But it's a corresponding advantage to the paying party. And so that's a neutral factor. It's not a factor that militates in favour of the higher setting court. Indeed, if the court were to say, well, you'll be deprived of the advantage of higher rates if we stay these proceedings, even if that were true, and it's very far from clear that it is true, but even if it were true, it's not a relevant factor because it cuts both ways. There are, of course, far more recent cases that restate the principle, but I would merely refer the court to the passages in paragraphs 37 to 43 of our skeleton where we refer to them. In that case, what I'll do is I'll turn straight to the conversant and unwire appellant decisions. I remind you that in unwire appellant itself, there was no dispute as to jurisdiction in the international jurisdiction sense. There were jurisdictional disputes of a different kind. So it's a conversant case one must turn to principally. And I will go through it, but what I'm going to do, if I may, is identify 6 important points of distinction between conversant and this case, which I would ask the court to keep in mind when we come to the judgments. And I'll do it before we come to the judgments so you can see the relevance of them as we go through. First, the evidence in conversant did not establish that the Chinese courts could or would set global license terms. They were therefore, the Chinese courts were not an available forum for doing that on the evidence in that case. And ultimately, that was the ratio in the Supreme Court. In conversant, the court was faced with a binary choice between the determination of global terms by the English court or a country-by-country determination, a sort of practical problem that caused Mr. Justice Burst to change his mind from his earlier view in Vringo and adopt the global licensing approach that he used in Unwire Planet, the revolution. Here, by contrast, we're not faced with that binary choice. Everyone agrees that there should be global determination, perhaps with a clause permitting local adjustment to cater for local conditions set by a single court. So the question in this case is not, should this court jurisdictionally go ahead with determining global terms, or should the parties be left to country-by-country determination in China because China is the biggest market? Here, the question is which court should set global terms? And it's a fundamentally different choice that we're faced with here. Second point of distinction, in conversant, the claim necessarily depended on findings of essentiality, validity and infringement for the reasons we explored a moment ago. Whereas here, although that remains an issue formally joined, it's clear that any license which either party will contend will cover the entire patent portfolio, irrespective of any issues of essentiality or validity of individual patents. Thirdly, in conversant, the English defendants were mandatorily sued here pursuant to Article 4 of the Brussels I recast, which meant that they could not normally obtain a stay on foreign non-convenience grounds, although Lord Justice Floyd did, obiter, agree with the line of cases that controversially had admitted an exception to this principle. The Supreme Court expressly said that it didn't need to address that issue on the facts of the case, the reflexive effect question, which is described, I think, in Dicey and Morris, one of the most difficult questions under the Brussels regulation. Here, by contrast, the court is freed from any such constraint by the ending of the Brussels regime in this country. Fourthly, in conversant, there was an ageing portfolio, so a stay might have a more adverse effect on the remaining life of the patents than would otherwise occur in the circumstances of this case. Fifthly, conversant was a patent monetizing entity that had bought up an old portfolio of patents, I think from Nokia, and here both parties are active participants in the market. They're both as patentees and as implementers. And so it's not as though this is a simple dispute between patentees on one hand and implementers on the other. As for this particular case, of course, on the way in which the parties are arranged in these proceedings, one's a patentee, one's an implementer, but they both have interests that fall both sides of that line. And sixthly, in conversant, the parties had not had a previous license, and there was a dispute as to whether Huawei was a willing licensee at all. But by contrast here, there has been a previous license, the parties were negotiating for a new license, and substantial sums have been paid for the use of each other's patents. There's no question of Oppo not being a willing licensee. So turning to the decisions themselves, I don't propose to go to unwired planets in the Court of Appeal, except just to note 2 points, which we can look at if you need to, but I'll just recite them. Paragraph 112, the Court points out that the question of appropriate forum should have been raised on an application for a stay, which had not occurred in that case. The first time jurisdiction arose was by way of a submission during the course of the hearing in the Court of Appeal, I think. They said it's far too late to do that. But there's no suggestion in that point that such an application would have been fruitless where the claimant alleged patent infringement. So as far as it goes, that's helpful to me. And in paragraph 206, the court made the point that it is desirable that an internationally accepted approach should emerge from these cases, and that it would be wrong to harmonise the approach on a first-to-decide basis. Now, turning then to the conversant case, we can probably go straight to it in the Court of Appeal. That's in tab 27 of bundle 2. The continuation patent pagination is 865. Whether that's bundle 2 number or not, I don't know. Bundle 287 in bundle 2. This is from the reports of patent cases. The court, in that case, accepted on, I think Judgment Lord Justice Floyd accepted that the application, on the applications, one must look at the case as a whole, including the defences, if they are known. In the conversant case, the issue of essentiality, validity and infringement were very much alive, in what we say here. May I invite you to turn straight to paragraph 97, which is deals with the characterization of the dispute. It's on the internal page, the report page 112. We have it at 2896, but I'm told it's page 318 in the internal numbering. Junior doing a very good job in picking up the page numbers. Paragraph 97, the judgment says this: it is clear that one may get different answers to the forum related questions depending on the level of generality at which one characterises the dispute. It is possible to define the dispute both in a way which is too specific and in a way which is too general. Thus, to define the dispute in a way which focuses on the relief which would be granted in the English court was to define it too specifically. See Harris Weller says. On the other hand, to define the dispute in so general a way that the claimant is left to pursue a claim based on a different property right, on different underlying facts in the foreign forum, is, in my judgment, likely to define it too broadly. So what the court then does is go on to engage in the process of characterization, and we can pick it up at page paragraph 101 over the page 114 on the report. In the present case, leaving conversant to seek a remedy in China would be to compel them to advance a case based on different patents. The Chinese patents are not the UK patents viewed through the lens of Chinese law. There are different property rights applied for and registered in China. They're not even in the same families as the UK patents. They will have different claims. Different prior art will be relevant to their validity. The issue of essentiality of those patents will give rise to wholly different technical issues from the issues which would arise on the essentiality of the UK patents. The acts of infringement relied on will be acts in China, not acts in the UK. I find it impossible to view such a dispute as being the same dispute as that which would arise in the English court. Pausing there, my Lord, what Lord Justice Floyd did not appreciate is what you have in evidence in this case, namely that the Chinese rate-setting claim is not linked to those property rights, not directly. There may be a substrat, there's an understanding that there are property rights which fall to be licensed, but the issues that he identifies there will not be issues in the Chinese proceedings. Here, unlike in conversant, the court is not faced with a claim in China being based on different property rights. As I've identified, firstly, the proceedings are not linked to essentiality, validity, or infringement. Particular patents, they take as a starting point a portfolio of patents and consider the licensing terms for the global portfolio as a whole. And secondly, as already pointed out, both parties want a global license that covers all patents without needing to decide the essentiality, validity, or infringement of individual patents. Now, there's no dispute that Nokia has some property rights that fall to be valued. That's common ground. The only reason they need to issue the individual patents here is because of the peculiarity of our procedure, as I've already said. The property rights that underline both claims are not the validity, infringement, and essentiality of individual patents, but the global portfolios.
Can I ask you a question about the law, which, speaking for myself, I haven't found a ready answer to in Huawei, perhaps because of the factual differences to which you have already adverted. And that is this question: what is the relevant date for assessment? And just to highlight the issue, if England was the forum conveniens on the date that the claim form was issued and served on the English defendants, which you told us earlier, I think was the 6th of July, how can it cease to be the forum conveniens because of proceedings commenced subsequently in another jurisdiction?
Well, the reason in this case is because the decision in Sharp and Oppo was handed down in August 2020. 2021.
I'm sorry, my question is a question of law, not a question of fact. What is the relevant date for the assessment of forum convenience?
Well, we say that the court views the situation as it is at the date it comes before the court. That it's unrealistic to take a purely historical view of what may or may not have been appropriate at the time. But what we say is that you don't ignore what we now know. We now know that the Chinese court had jurisdiction all along to do this. It's not as though it's a new jurisdiction that's been invented.
Well,
it had that
I don't
jurisdiction
think it will be in
July.
dispute that the court needs to take into account all the evidence that is available to it at the date of the hearing. But do I understand it to be your submission that as a matter of law, the relevant date for assessing the appropriateness of the forum is the date of the hearing, not the date on which the claim form was issued or served?
It depends what you mean by the date for assessing the relevance. I mean, you take account of the evidence that is before the court, including evidence that may have arisen since the date of the early hearing. Otherwise, there'd be no point in having a Latin Marshall application, because of course you take account of that evidence. Now, the evidence would be irrelevant if you only ever considered a freeze frame.
We've got case management as well in this case, so and clearly case management, the position is different. My question is directed to the question of forum.
Your Lordship says no ready answer is to be found in the cases. It would be strange if the law said you've got to take an historic freeze-frame view, the date of issue of the proceedings on a discretionary matter. The question of whether or not a gateway is satisfied is something that perhaps could be judged at the date of issue of the proceedings. We know that from Canada Trust and Stolzenberg, where the date of domicile of Mr. Stolzenberg was set at the date of issue of the writ. But the discretionary aspect, we say, is something that the court must judge on the basis of the evidence before it at the hearing, and not ignore the current reality. It would be very strange if the law says you must ignore current reality.
It would also be strange if the law said which a forum was appropriate on the date the claim was issued or served on English defendants ceased to be appropriate because of subsequently issued proceedings in another jurisdiction. That's a pretty odd result too, isn't it?
No, my lord, it's not the appropriateness does not depend on the subsequent issue of the proceeding. If so, no Spiliada case would ever succeed, because the whole point in Spiliada is that there is another available forum to which the jurisdiction of which the defendant is amenable, which can hear the case. It doesn't depend on proceedings actually having been issued in that forum, let alone prior proceedings having been issued in that forum. Spiliada wouldn't work.
That seems to lead to the conclusion that the right date is the date of issue, but in considering appropriateness of the forum, you take into account the possibility of proceedings in a different forum rather than their actuality.
Well, if actual proceedings have happened, then you take them into account. If they haven't happened, you take into account the possibility of them. But my point is, if you judge appropriateness only at the date of issue of the claim form, Spiliada would be almost entirely unworkable. It's never been the case that prior proceedings in another jurisdiction are a requirement for the appropriateness of that foreign jurisdiction.
That plainly is correct, as you say. Otherwise, the question would frequently never arise. But do I understand, therefore, you to be accepting that the question we should be asking ourselves is, let's take the date of issue for the date of convenience, particularly because it is the day after the previous licence ended, 1st July. So we ask ourselves, as at the 1st of July, what was the appropriate forum, having regard to the fact that there was the actuality of proceedings being issued that day in this jurisdiction and the potentiality of proceedings being issued in Chongqing.
Right, again, if I may subdivide it into gateway issues and discretionary issues. You ask yourself, is the gateway satisfied as at the date of issue of the proceedings? By gateway, of course, I refer to the subparagraphs of paragraph 3.1 of Practice Direction 6b. You ask yourself, is that test satisfied as at that date? If that is, the court then has to go consider, at the time it's considering, which is the appropriate forum. But the appropriateness of the forum doesn't depend on the issue of foreign proceedings. Maybe if the proceedings have been issued and made progress, that's something the court takes into account, and it may assist on the assessment of the appropriateness, but it doesn't depend on it. And so it can't be.
So would you accept, therefore, that it can't depend on factors such as relative timings? No, unless, of course, one's in an extreme case where you can say, well, it'll take forever in the putative alternative forum, and therefore that's not a realistic alternative.
But you weigh all of that. You weigh all of that, including what the court now knows, both prospectively, as to what is going to be the appropriate forum for the resolution of this dispute when it comes to be resolved.
Seems to suggest that the assessment can fluctuate.
Of course it can, yes.
And so the longer the hearing goes on and the more appeals there are, so the assessment will vary.
Yes, if Nokia hasn't challenged the dispute in the jurisdiction of the Chongqing court, then the appropriateness of the Chinese court would be even more apparent, because we would have embarked on and possibly even got a decision on the FRAND.
It's a jolly odd approach to deciding what's the most appropriate forum. So case management, of course, is a different story. I can see that.
No, the appropriateness of the forum, it's very clear in Spiliada, it requires the court to take everything into account, all the circumstances.
You say there's no conceptual problem.
No.
with a forum that is convenient at one particular date, not remaining or becoming an inconvenient forum by the time the decision comes to be taken. There's no conceptual problem with that.
There's no conceptual problem as such, because the court has to judge the matter as it appears before it at the time.
Well, it seems there's a difference, isn't there? Where you're talking about service within the jurisdiction, there's no requirement that that service is that the proceedings are the convenient forum. If you can serve, you can serve. And then there's a subsequent application saying this is not the convenient forum. Must be judged at that date.
Yes. So
it's different though. Service out of the jurisdiction, where it is a requirement of granting permission to serve out, that England is clearly and distinctly the appropriate forum.
yes.
And so it seems to me that when there is then an application to set that aside, the question is, was that decision rightly made? So that seems to me that is a retrospective exercise.
Well, with respect, no, my lord, because the decision will in nearly every case have been a without notice decision. And so not was it rightly made at that time, but at the time there's first opportunity for the two parties to debate it. In this court, the main question may be whether the learned judge was right at the time he was judging it, to judge that. But it can't be the case that the appropriateness can be judged by reference to one side's evidence.
There's definitely a hearing. There's definitely an inter-parties hearing, and the burden remains on the party making the application.
Yes.
But permission has been granted, and the question is whether or not that permission should remain, or whether it should be set aside. So it seems to me you can't you can't logically say you can't logically say, well, it was right when it was made by the judge without notice, but it is no longer right.
With respect, one can for this reason. That let us say if the judge made it on the basis of inadequate evidence.
That would be different.
Well, conceptually, I'm not sure I can see how it could be different. It's only when you have an inter-parties hearing where both parties get an opportunity. It's not a review jurisdiction. The set-aside application is not a review. Was the judge right to make that decision?
Well,
it's de novo.
You quite often in service overseas, it can take a long time before you come back to the jurisdiction dispute. And it seems to me that, particularly if a defendant has chosen not to accept service or to make service difficult, that he can come back a year later and say, well, permission may have been rightly granted without notice in 2020, but now in 2022 it's no longer the appropriate form.
The nature of the set-aside application, analytically, is not a review jurisdiction. It doesn't review, was the learned judge right on that unilateral application on one side's evidence to reach the decision he did. The question is, what is the right decision to make on the basis of having heard both parties?
Oh, I agree that it's not a review, it's a fresh hearing, but you must be looking at it as at the date the without notice order was made.
I don't understand why that must be the case, my lord.
I wonder also, I don't think this is a point that's essential to your argument, and the point was raised by the court, but I think we may need to push on with the points you want to make about this.
Well, thank you, my lord. My point is there's no mechanistic question, and it's not a question with respect to Lord Justice Arnold. You can't say something that was appropriate on day one, ceasing to be appropriate by day 5, because of some change of circumstances. You judge on day 5, because that's the date the court's hearing it, whether it's appropriate.
Well, let's
it's
move
not
on
a
that.
review jurisdiction. Otherwise, Spiliada wouldn't work.
On that basis.
I was just going to. So, Lord Justice Arnold, I understood you here asking another question. Fine. May I then ask the court to go to tab 31 to see unwired planets in the same bundle, see unwired planets in the Supreme Court. Now, again, the facts are sufficiently uncontroversial for us not to need to go with those. One can pick it up at paragraph 92 starts the topic of forum non-conveniens on page 1172 internally, 1010 externally. I'm not sure what page.
432.
Thank you. One can then go probably straight through to 95 on page 1173. the question of how the dispute should be defined has been the main bone of contention between the parties, both in this court and in the courts below. May I just pause there, my lord, to point out something that occurred at first instance in Conversant and may have defined the language used after that, which is that there was an argument being addressed as to the justiciability of such a claim in the English courts. That was not pursued on appeal, certainly not by the time it got to the Supreme Court. So the question of characterization was relevant to the justiciability issue. At all events, the Supreme Court said that. Is it, as the appellants say, in substance, a dispute about the terms of a global FRAND license, or is it, as the respondent maintains, both in form and in substance, about the vindication of the rights inherent in English patents, and therefore about their validity and infringement, with FRAND issues arising only as an aspect of an alleged contractual defence? Thus far, the respondents had the better of the argument, both before the judge and the Court of Appeal. The heart of the analysis, which has thus far prevailed, is the recognition that the owner of a portfolio of patents granted by different countries is in principle entitled to decide which patents, and therefore in which country or countries, to seek to enforce, and cannot be compelled to enforce patents in the portfolio granted by other countries, merely because a common FRAND defence to the enforcement of any of them raises issues which might more conveniently be determined in another jurisdiction than that which exclusively regulated the enforcement of the chosen patents. That's proceeding on the assumption that the property rights lie at the heart of the dispute, and in this country, for the reasons that Lord Justice Arnold identified, that remains the case. But it's not the case in China, because you won't be examining the underlying validity of individual patents. It's the starting point, the common ground starting point, is that there's a global portfolio. Going to paragraph 96, where it's necessary to choose between the rival characteristics of the substance of the dispute, we would have agreed with the choice made by the courts below. But we think, like the judge, that there is a compelling reason why the appellants must fail on this issue, which would apply even if the appellant's characterization had been correct. So the dispute was in substance about the terms of a global FRAND license, as we say is the case here. Challenge the jurisdiction on forum grounds requires the challenger to identify some other forum which does have jurisdiction to determine the dispute. Even in a case where permission is required to serve out of the jurisdiction, so the burden then shifts to the claimant to show that England is the more appropriate forum, that still requires there to be another candidate with the requisite jurisdiction. In the present case, China is the only candidate which the appellants have put forward. In paragraph 7, after hearing extensive evidence, the judgment found that the Chinese courts do not at present have jurisdiction to determine the terms of a global FRAND license, at least in the absence of agreement of all the parties that they should do so. Two lines down, notwithstanding the admission of fresh evidence on this issue, the Court of Appeal reached the same conclusion. In sharp contrast, we have decided, for the reasons set above, that the English court does have such a jurisdiction, even in the absence of consent by the parties. And it has, of course, been exercised, that jurisdiction, in the unwired case. The court will recall that in the Supreme Court was the first time that both unwired and conversant were being considered together, because they'd taken separate courses up to that point. At 98, we therefore agree with the judge that the foreign convenience challenge falls at this first hurdle, notwithstanding the fresh evidence introduced in the Court of Appeal. And then, had it not done, a number of further issues would have arisen, in particular the application of the Owusu principle, set against the possibility that there might be a reflective application of Article 24 of Brussels. So what is being clear there is that while they agree with the characterization of the Court of Appeal, that's not the reason they take the decision. The reason they take the decision is not because it's characterized as a patent implementation case, but because there is no other court, no other available forum for determining the infringement issue. Now, or indeed, no other court available for determining the global FRAND license. So even if it had been characterized as a global FRAND case, conversant would have lost because they failed to establish that there was another available forum.
But they did accept, they did say that if they needed to choose, they would have made the same choice.
If they had to choose, they would see that that particular case was one where the property rights were at the core of the dispute, where it was not clear that Huawei was a willing licensee, that the validity infringement were live issues rather than, we say, dormant issues here. That in those circumstances, as Lord Justice Freud said, it depends where you look at it on a scale, too broad or too narrow. He chose a characterization that took account of the fact that those property rights were very much in issue in that case, as we saw in the Court of Appeal a minute ago. And the Supreme Court says, well, as far as it goes, we don't disagree with that, we agree with it. But it doesn't matter, because there isn't another available forum.
Where is this submission going? I mean, this line of authority seems to be against you.
My Lord, no.
It's
because
against you in the Court of Appeal, and had it been necessary, it would have been against you in the Supreme Court.
No.
What is your? I'm trying to grasp what your submission is about this. Is it that we can just ignore this?
I'll come to that if I may now, my Lord, which is how you apply the principles in the case. On characterization, the learned judge treated this case as the same as conversant, paragraph 45 of the judgment, notwithstanding that he'd held that the availability of an alternative forum was a point of distinction from conversant. I should just correct an error in our skeleton argument. In paragraph 47 of our skeleton argument, we put some words as if they were a quotation. It's actually a summary rather than a quotation. Now, we don't criticise the learned judge for having adopted a characterization approach. In doing that, he was following the lead of both conversant and unwired planet. But although we do wish to reserve the right to argue the point if this matter should go further, I'm going to put that marker down. Our criticism, rather, is that in adopting the characterization approach, he lost sight of the fundamental Spiliada principles and treated the characterization of the dispute, which he characterized as a patent infringement claim, as determinative of the forum issue. And that's the point, that's where the submission goes. He made the mistake made by blind men inspecting the elephant. The blind man observed a small truth, but in doing so fails to see the whole or larger truth. Seeing this as a patent infringement case fails to see that the real truth is that the big dispute is about license terms. The whole or larger truth is the dispute as a whole has to be assessed for Spiliada purposes. It's not sufficient just to say this is a patent infringement case. Now, it is significant that the Supreme Court did not regard the characterization of the dispute as determinative, unlike Lord Justice Freud. To the contrary, it was the non-availability of China as an available forum that formed the basis of their decision. And whether the judge fell into error was following the Court of Appeal rather than the Supreme Court on this point. Now, if I'm right about that, the learned judge was in error in that regard, we then come to look at the factors which point to England point to China rather than England. I'll list them briefly. The Chinese courts are an available forum for determination of the global license terms. None of the principal parties are English principal parties. Most of the products covered by the patents are manufactured in China and are covered by Chinese patents. Most of the products are sold in China, India and Indonesia. Europe accounts for less than, the whole of Europe accounts for less than 5% of global sales of Oppo products. UK accounts for less than 0.5% of global sales. Maybe that's why Oppo's name features so prominently on the hoardings in Wimbledon that you see on your television. Fifthly, the main sources of revenue under the license will arise in China, even if a lower royalty rate is set for China, because of the volume of sales. And the Chinese courts are already seized of the global license issue and subject to Nokia's jurisdiction challenge, which has failed at first instance, as between different Chinese courts. The Chinese courts are ready to get on with it. All of these point to China as being the appropriate forum. Now, I just then, before I wait to Mr. Alexander, deal with a point raised by Nokia. They say, in effect, that China is not an appropriate forum because the Chinese court would not approach the rate-setting exercise in accordance with French law, which they say treats the ND, non-discrimination aspect of FRAND, in one way, while the Chinese courts would approach that differently. Now, we say there are a number of difficulties with that argument. Even if it's right, it's not a factor which this court should properly take into account, or in a certainly not in a determinative way, as decisive. It only becomes decisive if it passes the high threshold of depriving a party of substantial justice under the second limb of Spiliada. Except that it's a factor if it's right. But there's no evidence, or even a suggestion, that Chinese determination of global FRAND would deprive Nokia of a substantial justice. That's enough to dispose of the point. But even in any event, there's no evidence that the approach which this court adopted in Unwired Planet was based on French law. To the contrary, Mr. Justice Burse had no evidence of French law on that point. He had evidence of French law on the stipulation pour autrui, the question of beneficiary of the Etsy undertaking, but no French law evidence on the application of non-discriminatory tests. And indeed, we've noted, I think, in our skeleton argument, a point where that has been accepted by counsel for Nokia in an interlocutory hearing in this case. The evidence of Ms. Lau is that the Chinese court may adopt a range of approaches to evaluation, including a so-called top-down approach, which is one of the approaches which Nokia is now contending in this case and was used by Mr. Justice Burse in Unwired Planet as a cross-check. And she goes on to say also that the court, the Chinese court will take account of different methods of valuation in order to reach a fair valuation. Her evidence on this is in tab 10, paragraph 21, that's Liao 1, paragraph 21. In paragraph 32 of their skeleton, my learned friends make the point by reference to a number of cases. I don't, I think, need to go through them, but I make my submissions in relation to them. Firstly, they refer, perhaps we should just look at paragraph 32 of their skeleton so you can see exactly what they're saying. On application of proper law, they say, if, contrary to the above, the court would find the dispute is one concerning the terms of a global FRAND license, and there is an alternative forum for that dispute in Chongqing, it would be necessary to engage in the comparative exercise described by Lord Briggs in Vedanta. Well established, the law to be applied in each forum is an important factor here. Well, I accept that from Spiliada onwards, the applicable law is a factor. I certainly don't accept it's necessarily an important factor. Indeed, if it were an important factor, it would be far more successful for non-convenience applications in the commercial court than there are. The commercial court goes out of its way frequently to say we're quite capable of dealing with foreign law. But then they cite a number of cases. See, for example, Banco Atlantic. That was a case where a stay was refused on the grounds that a stay would lead to a summary rejection of the claims, not on the basis that they would apply the wrong law. It was because of the summary rejection of the claims that was where the stay was refused in those circumstances. That is the correct approach, is because it can be seen from the judgment of Mr. Justice Hamblin, as he then still was, in Cecil and Byatt, where he was dealing with a number of denial of justice cases. I can go to this if it's helpful, but again, I can just tell you, and if it's disputed, my own friend can take you to it. At paragraphs 23 to 27, he's looking at a number of denial of justice cases, and he makes clear at paragraph 27 that Banco Atlantico is a not conducive to justice case because of the summary rejection of the case in Sharjah, not by reason of the application of the wrong law. So the application of the wrong law doesn't make a forum inappropriate. Vedanta, in paragraph 2066, which is cited by my own friends, merely identifies the applicable law as one of the connecting factors. Of course it is, no dispute there. In Varma number 2, parallel Bulgarian and English proceedings, And one issue was the possibility that the Bulgarian court might not apply English law, even though English law was expressly chosen as the law of the contract. And all that case does is to illustrate that it's a potential factor. In the event, it made no difference in that case because no one had tried to argue what English law was for the Bulgarian court. The evidence was that the court probably would apply English law anyway, and there was no difference between English law and Bulgarian law that had been identified. Lord Justice Lawrence Collins, who of course on these issues is always particularly interesting to look at in Novus Aviation, we can look at that perhaps. That's in the first bundle at tab 15. This is one of the two decisions of his cited by my learned friends, the other one being Chris Sawyer at tab 13, but that was the first instance decision and is referred to by Lord Justice Lawrence Collins in this case. We don't need to worry about the facts particularly, we can pick it up straight at paragraph 78. Factors which may weigh in favour of the English forum would include the fact that issues of English public policy may be involved, or the fact that the foreign forum, notwithstanding the express choice of English law, may not apply English law, may instead apply its own law. But in Sawyer, I suggest that assessing the significance of a choice of English law is not an exercise in the counting of contacts, but of identifying, so far as is possible, in the absence of a formal defence, the issues, and then considering the appropriateness of the competing fora. So we say the way you look at foreign law is if somebody's going to be saying, oh look, the Chinese court won't be applying what we would regard as the proper law, you look at the significance of that. You look to see why is it significant, and the evidence needs to be put in as to what difference it would make. And we say that the evidence here does not show any significant difference, that Nokia is quite capable of having a perfectly fair valuation in the Chinese courts. In addition, we could make the point that it's not clear, as the point I made a moment ago, not clear that the English court applies French law to the determination of non-discrimination. The Supreme Court made clear in OY that it's to be treated as a general factor, that FRAND is a unitary concept including non-discrimination, what's called general non-discrimination, rather than a hard-edged non-discrimination which would give priority or exclusive priority to comparables. So we say in none of these cases qualify the essential point that the applicable law is a factor but no more, and only if substantial justice is denied as a result of the application of the wrong system of law, in English eyes, is there a reason not to grant a stay in favour of an otherwise appropriate forum. Nokia also made some points about judicial experience. We say that's not a strong point. China can do it, has done it domestically, including in Conversant and ZTE. This country can't claim a large amount of experience in the field. It's only actually happened once so far in On Wire Planet by Mr. Justice Burse, and his experience won't be available for trying this case because he's now in this court. Several cases have been launched, but only ever one judgment's been handed down, although there is another one pending, I think, for Mr. Justice Mellor at the moment, awaited. They make a point about English as the language. Well, that's the language of commerce, but there's no reason to suppose the Chinese court can't cope with English any worse than this court could cope with Chinese, and perhaps with respect, rather better. And finally, we rely on the forum aspects on the points which would warrant a case management stay, to which Mr. Alexander will now turn, unless there's any further point on which I can be of assistance.
Thank you very much, Ms. Lane. Yes, Mr. Alexander.
Mine will 6 points. Briefly on the legal framework. Secondly, why these kinds of cases raise particular issues. It's obviously said against me this is a case management decision and discretionary and so forth, and I need to get over a hurdle to persuade my lords that this is a issue of wider significance. Third, how the case management powers should be exercised in cases of this kind, and specifically this case. fourth, why arbitration is not a solution here and may not be a solution generally. Fifth, the judgment and the respects in which we say His Honour Judge Hacon was entirely right, but in some respects beside the point on case management in his decision on that. And then when he came to make his ultimate decision, fell into error right at the end. And finally, what the court should do in the light of that. So can I turn, first of all, to the legal framework? And in the interests of time, because three of the cases that are of importance were cited in the judgment, perhaps I can come to those when I deal with the judgment. That's Reichhold and two of the unwired Planet cases. Just by way of a segue from forum non-conveniens to this aspect, if my lords would take up the Reichhold case, which is in Joint Authorities. That's not going to help, my lord. Joint Authorities 1, tab 8, but it's at the appeal bundle number JA154. The case there emphasised, and the judge at first instance implicitly approved by the Court of Appeal at 182 in the bundle at B, the difference between the jurisdiction in relation to forum non-conveniens and case management. And it can be simply expressed in that forum non-conveniens is about where and case management is about when. And Mr. Justice Moore-Bick put the matter as follows: in the case where a stay is sought on the grounds of forum non-conveniens, the availability of an alternative forum for determination of the dispute means that the court is effectively being asked to decide in which of two competed forums the action shall proceed. In practical terms, it's not a question of when, but whether the plaintiff should be allowed to pursue the action here. To that extent, the exercise of the court's discretion to stay the proceedings involves a greater interference with the plaintiff's rights than the order sought in this case. And that was picked up later by the Court of Appeal on at 185 at F to G, where he approved what Mr. Pollock was submitting in that regard. So my lords are, in this aspect of the case, are applying a quite different approach. And one of our criticisms of the decision below was that the judge conflated matters that are of relevance to forum non-conveniens, the primary relevance on forum non-conveniens, and appear to regard those as of particular significance in relation to case management stay, when he ought to have been focusing his attention on other matters, and in particular the incremental benefit. The only other case, just to refer my lords to right at the outset, is a case where we have extracted a portion in our skeleton argument. That's at Joint Authorities 491 at 537, Autoridad del Canal de Panama, a decision of Mr. Justice Blair in the Commercial Court, and at paragraph 165, and that's the paragraph we quote in our skeleton, he says that the authorities show that the approach of the court to an application for case management is not for the court to dictate what a party's course of action should be. If a party has contractual rights, it's entitled to enforce them in the contractual jurisdiction. On the other hand, it's not correct that because of the exclusive jurisdiction clause, defendants have, inverted commas, a mountain to climb. In circumstances in which an international commercial dispute involves arbitration as well as court proceedings, it makes good commercial sense for the court to have regard, where appropriate, to the orderly resolution of the dispute as a whole, necessary by granting a temporary stay in favour of arbitration. A coherent system of commercial dispute resolution has to take into account the fact that various different tribunals may be involved, each of which should aim to minimise the risk of inconsistent decisions and avoid unnecessary duplication and expense. All this is amply supported by the case law. And we respectfully commend that to you. And part of the reason we do so is precisely because there is no agreed international single tribunal to resolve these disputes. And partly because there is a degree of controversy in relation to the role of given tribunals deciding these matters on a global basis. And we have a situation in which, in brief terms, both the English courts and the Chinese courts are claiming rights to do so according to their own respective procedures. And we also have a recognition that whatever the position on forum, case management, and so forth, it is right, for, at least for this court, to respect the decision or seek to respect the decision of the Chinese courts within its sphere, and I'll come to the authorities in relation to that. And because there is at least a prospect that if the Chinese court makes its decision in relation to this, in relation to the primary market, that is a matter that may be accepted by the parties or may only require modest adjustment. I'll come on to the adjustments in due course. It makes sense for the Chinese proceedings to proceed as expeditiously as possible, and the relatively expensive and inconvenient English proceedings to only be reactivated or reanimated when those proceedings have taken their course, if it is necessary to do so. And I'll come on to address head-on my Lord's questions about, well, why is it necessary for there to be all these expensive English proceedings and technical trials and so forth, because that's a point that's clearly troubling my Lords. So that's the legal framework. May I then turn to the second aspect, which is the significance or wider importance of these cases, and just take a few moments to explain that for those who are perhaps not quite as steeped in this rather nerdy area of law as all members. Underlying these cases are two common factors. First, we're dealing with standards essential patents, which makes it sound rather dry. Actually, what we're dealing with is one of, in some ways, the greatest triumphs of modern collective technological achievement, where people come together to create really an extraordinary thing. The standards makes it sound rather mundane. These are designs for technology that involve trying to optimize mobile communications. And essentially what is going on here is that the parties to this endeavor need to work out what respectively they have put into the technology pot and what they should be taking out of the technology pot as a result of what they have put in. So that's the general framework, and I put it in that simple level because that's the underlying point that gives rise to these disputes. It's a very complex process. If one imagines designing a jetliner, it's as complex as that, if not more. But equally with a jetliner, there are parts that are important and the parts that are not important. One can envisage the wing design and so forth being really quite fundamental. And on the other hand, the toggle on the life jacket, even though it may be standardized, everyone's operating in accordance with that design, may be less important. So there are issues of contribution and so forth. Second feature, which my Lords will of course have appreciated, is that there is an element of moving eastwards in the technological focus, both in terms of those who are using the design, because mobile technology is largely done, particularly with mobile phones, now in China and some other countries. Obviously, Apple and Samsung have very substantial positions, but equally contributors to technology are moving eastwards. There is, as at least one of my Lords will know, a rather active debate about who is in the lead in contributing to the 5G standards, whether it is companies in China or whether it's companies in America, and there are tussles for this technology. That gives rise to these cases being potentially very fundamental cases on a global basis, and partly because of the way that the internet has moved, including into the Internet of Things, where one's fridge can operate using the Wi-Fi protocol, or indeed a telecoms protocol. The number of things, products and undertakings that potentially make use of these designs is very significant. And I'll illustrate it in this case. There's a further factor, which is that in this case, both claimants and defendants are patentee and implementer. That's why one's in a situation of a cross-license. But cases of this kind are likely to be increasingly common in the courts. Here we have a case where one's dealing with a continuation license in a sense, or renewed license, where the question for the court is, well, should the terms be altered from the earlier license, and if so, how? If one envisages these kinds of cases being undertaken regularly in these courts, the question will arise again and again. of the kind that is currently before my lords. How should these cases be managed? Should one have a situation in which, where there are parallel proceedings to set rates in China, the English courts should go ahead at the same time and at the same pace, or indeed, even as it's sometimes said, ahead of that? And if so, how is this kind of jockeying for position to be managed? And the watershed change, as my learned friend Mr. Layton has explained, is in a sense twofold in this litigation. First of all, in Unwired Planet in this country, saying that the English courts have, if I can put it in general terms, authority to settle terms on a global basis. And the second watershed moment was last year, when the Chinese courts said, well, if you, the English courts, have got the authority to settle terms on a global basis, why don't we also have the authority to settle terms on a global basis? Indeed, the sotto voce for some of the decisions is it's even more appropriate for us to be doing it, given that that's where the technology is being developed and being used, and it's inappropriate to have a relatively small, and I use that in a not disrespectful way, country seizing jurisdiction to determine these matters on a global basis, and it's more appropriate that it be done here. So these are issues of management that are likely to arise on a frequent basis, and they have consequences for the way in which these cases are managed in England. And my lords have seen that play out. What do the cases actually involve? Well, this case is a good illustration. 3 patent trials, potentially. In this case, there's a further trial to determine what undertakings should be given, and a substantial FRAND trial. When I say FRAND trial, it's kind of commercial trial, now set for 15 days. If one actually tots up the amount of time that is potentially spent on a single dispute of this kind, it comes close to being one judge term's worth, if I may put it like that. If one thinks about 3 very substantial technical trials, reading in, spending time writing the judgment, then a 15-day FRAND trial, that is a very significant chunk of party resource. It's a very significant chunk of judicial resource.
There's nothing new about that. I mean, that goes back all the way to IPCOM.
Indeed.
We've had more than a decade of experience with that aspect.
Indeed. And I'm not saying that's a good or a bad thing, but it is the background against which this operates. And my more substantive point, though, is that the effect of Unwired Planet in the Supreme Court is that it might be said to open the door to this forum being used more for global disputes of this kind. And one's seen a significant number of undertakings using the courts in this way. And so the question is, well, what is the most efficient way to deal with this? Now, my lords have raised a question, well, what are these technical trials doing? And in some senses, this is a question that is appropriately directed at Nokia, not at my clients. And the reason is this.
How can that be right when it's only down to your clients that the issues need to be tried at all? You could concede essentiality and validity right now, and the 15 days of court time would disappear in a puff of smoke.
Well, but what would also disappear in a puff of smoke, were we to do that, my lord, is that it would be said immediately by Nokia, I have absolutely no doubt, is that, well, now you have conceded infringement and validity in relation to those patents, 2 or indeed 3 or possibly more things would happen. First of all, there would be an automatic right thereafter to a determination by the English court on a global basis of FRAND terms. That is precisely what my clients say should not happen. The second thing that would automatically happen, because that is the effect of Unwired Planet and conversant in the Supreme Court, is that Nokia would say, now you have conceded infringement and validity in relation to at least one of these patents, there must be an injunction excluding all of Oppo's products from the market unless you take a license on terms determined potentially exclusively by the English court. That, again, is something...
Well, no, because at that point, you could raise your jurisdictional argument. You could say, yes, of course, we are ready, willing and able to take a global license on FRAND terms. The only question is, who gets to decide.
But at the moment, that is not a course that is open to us. Because
Why not?
Because at the moment, the effect of Apple and Optus, at least arguably, and will be said by Nokia, is to say,
It wasn't the position in Apple and Optus. It wasn't the position that Apple was saying, yes, we're ready, willing, and able to take a global license on terms to be settled in Chongqing. That was never
No,
an issue.
My lord is absolutely right. That was not an issue in Apple, and indeed in the Lenovo case, Lenovo Interdigital case, which is in the bundle, His Honour Judge Hacon made exactly that point, that was not a point in issue, but it was a point that was argued by Interdigital, where it was said, and it may be a matter upon which Mr. Justice Mellor ultimately reaches a decision in the Lenovo Interdigital case, where the point is outstanding, that the only way in which an injunction can be avoided by an implementer in this country is to take a license not on terms settled by this court, by the court to which it is given an undertaking, namely the court in China, but by this court and this court alone. But there is a third consequence of admitting validity and infringement in relation to these patents, which, it has to be said, may neither be valid nor infringed. Namely, it would be said, in one of the other myriad proceedings that Nokia has commenced in many other countries, including in Europe, well, now you've admitted validity and infringement, there should just be an injunction. So, my lords, we cannot, as it were, subject ourselves to what would be a gun to our head commercially, either as a result of the effect of English proceedings, which may be argued to be the effect, or as a result of foreign proceedings. And my lord, this is all we have tried, and my lords have seen our attempt to try and deal with the English proceedings in this way, where we said, well, all right, we're quite prepared to accept that if this matter is determined in the Chinese courts on a global basis, if Nokia is dissatisfied with that result as it applies to the UK, or indeed the whole of the EU, sales in the EU, then these proceedings, and the FRAND proceedings, can be reanimated.
Yes, but you see, you're not even prepared to agree to FRAND being tried first and infringement and validity later, if needed.
We are, my lord. My lord, that is exactly what we are proposing.
No, in this country.
In this country, we are not, but that is because...
No, exactly so.
No, my lord...
So what it's all about is which country should decide FRAND.
My lord is absolutely correct. And that is the...
And you're not prepared to agree to a neutral forum either.
Well, my lord, we have articulated in the note the reasons why court determination is considered to be appropriate. We don't accept a characterization of the Chinese court as not being a neutral forum. It is a court forum, and as we have explained in that note, court proceedings for determination of these matters is the default. It's provided for by the ETSI guide, and that is the approach that we have adopted. And if I may respectfully say so, it is the approach that Nokia has adopted as well, and I'll show my lords that in due course. So, in our respectful submission, it is a little bit like saying to someone who is facing a threat of exclusion of their products, well, why don't you simply submit to what Nokia wants? Well, we respectfully say we are...
Nobody's suggesting you should simply submit to what Nokia wants. On the contrary, the question is one for dispute resolution, and the only question is what is the most appropriate and efficient method of dispute resolution.
Indeed. Indeed, and that is, and there is a fundamental difference between the parties in relation to that. Nokia says that they wish to have the dispute resolved either in the English courts. I don't know what their position is now in relation to arbitration. They haven't yet said. They may say, well, we want to do it now. We say that it is appropriate for this dispute to be resolved in a court and in particular the court that we have selected in China. And in our respectful submission, that is not an unreasonable position to take, particularly in the light of the fact that the members of F have not been able to agree collectively.
Again, nobody's suggesting that your client's position is unreasonable. It is eminently reasonable for each side in a dispute to want the dispute to be tried in the forum which it considers most favourable to its position. It's what everybody does, and it's perfectly reasonable to take that approach. The question is, objectively, given that neither side on this assumption will agree to a neutral forum, how one decides, applying conventional principles, upon the resulting jurisdictional dispute.
My Lord is, of course, absolutely right. Or, what one might say, is how, at least on the case management aspect, the choreography of the proceedings should be arranged in order for that to proceed most efficiently, in the light of the fact that the parties cannot at the moment agree on which should be the forum. Now, our overall submission on that, as my lords would have appreciated, is that given where matters respectively stand on the United Kingdom proceedings and the proceedings in the Chinese courts, including given the timing of those proceedings, which it has to be said is uncertain in the light of the evidence, but in particular the cost and relative inconvenience of pressing ahead with England in the meantime, what makes more sense is to proceed with the Chinese case initially, and then, if it be necessary, to proceed with the English case. And in our respectful submission, that is a perfectly reasonable approach. That the proceedings in China are likely to be less costly, they're likely to involve less inconvenience. They obviously will involve less inconvenience for the English court than pressing ahead with the English proceedings. But most importantly, it is perfectly possible that those proceedings will render the English proceedings unnecessary. One cannot assume that once the Chinese court has made a decision, that decision will not be accepted by Nokia. It may not be, I accept that, and it may be that they say, well, we don't want that. It may be that they say, well, the Chinese court is going to apply an approach which is inappropriate, but it may not. And His Honour Judge Hacon, in our respectful submission, entirely correctly identified the fact that the fears, for example, that French law approaches to non-discrimination may not be applied or may have relevance in this case, simply may not materialise, because the case may not even be advanced on that basis in China, or indeed that it would have any purchase at all, because for all one knows, Nokia may say, well, this is the most favourable license, for example, and you should be paying on the basis of a comparison with that. So our respect.
Could I ask for your help?
Yes.
Just to give me the picture, not that I'm suggesting that this determines what we might decide, but let's suppose that the proceedings continue in both jurisdictions, and one will decide FRAND terms before the other, and the one that is second will decide whether it ought to decide FRAND terms in light of the first decision, and might decide to do it as well. So it's possible that there might be two FRAND rulings of worldwide effect. Am I all right so far?
My lord is, unfortunately, exactly right.
Right. So, in one sense, of course, one's first reaction to that is how very unsatisfactory. In another sense, one's response might be, what's wrong with that? Unless the industry can, as it were,
sort itself out.
Catch up and sort itself out. Isn't that just the sort of result that is likely to lead to a proper global system of dealing with these issues? And so I'm just saying that one's normal domestic approach to this, which is to have a horror of inconsistent decisions, might in the wider canvas of this developing world be something that isn't as bad as all that.
I'm tempted to say that what is proposed is a Leninist solution in this sense.
Well,
I think my Lord knows what I mean by that.
Can I just stress that may be a very unsound driver for thinking of any kind, but and just looking down the road of these sorts of disputes, isn't that what might or might not eventuate?
Yes, one could think of that, and that one creates a situation that is so unsatisfactory, if I may put it like that, that it forces
Well, it means
alternative approach.
not letting either side to this sort of dispute have their own way.
My Lord, yes, and there are a number of other options on this. For example, just to follow my Lord's thinking, because it is thinking that the English courts have had in a slightly different form in this context to which we refer. It might be said, well, all right, once two courts have decided, then a question may arise. Well, should the decision of one court apply in sphere A, and the view of another court apply in sphere B? And that is not an unreasonable
Well, there would clearly have
approach.
to be, at the point where there were conflicting decisions, there clearly have to be a sorting out by one means or another. I understand that. Anyhow, I didn't.
Indeed.
I didn't want to divert you from your course.
My Lord is absolutely right, and in a sense, my Lord has identified the key point, because that might be said to be the default position, and indeed it was the position that Nokia advocated below. They said, well, what they want is for these proceedings to continue in parallel, effectively, and for matters then to be sorted out in some way in due course. In all respectful submission, that is a solution, and I don't say that's not a solution. But the question for case management, in all respectful submission, is whether that is the optimum solution. And we respectfully submit that where there is an alternative solution available to that parallel approach, which involves saying, well, let the, inverted commas, big jurisdiction decide first, and then see what is necessary in relation to the United Kingdom, that is a better solution than simply allowing these proceedings to go ahead in parallel. And the reason that it is a better solution is because if one then does this parallel route, one is essentially forcing upon the English court an inevitably expensive proceeding, whether or not the technical trials come in, because we're dealing with a 15-day trial in any event in this country if there's a FRAND trial, which may not be necessary. And in our respectful submission, if there is a choice that this court should make, it should make the choice of saying, well, let's hold on and see whether the dispute in China will resolve matters. And to follow my learned friend Mr. Layton's point or analogy with stays pending mediation, stays pending arbitration, and so forth, one might say, well, if there is an alternative means for resolving the whole dispute, which may take place at lower cost, at reasonable time, and so forth, than the proceedings continuing in the English court, the English court should give careful consideration to whether that course is preferable. In this case, one might say, looking at it in a slightly from the wrong end of the telescope, that the Chinese court's approach is alternative dispute resolution to the English court's approach. It is saying,
and vice versa.
One could say that. One could say it vice versa, because there is complete symmetry on one view between these, except what we say is the symmetry breaking element is that the dominant commercial activity and so forth takes place in China. All of the points that have been made in relation to forum non-convenience. So we respectfully submit that that is a big point, as well as the fact that relatively in terms of time and in terms of cost, the Chinese proceedings are likely to be lower cost, and
The judge made no findings as to relative cost, did he?
no, he didn't. There is some evidence in relation
It's
to
not a ground of appeal either.
No, my lord is right, and so perhaps I'll leave that for the time being. But in any event, I think it's fair to say that whether or not the Chinese proceedings would be less or less costly, it is certainly the case that the English proceedings, whether in full form, including technical trials, or in FRAND form, would certainly be costly. And my lords will know that the FRAND trial, the only FRAND trial the English courts have done so far in unwired planet, was a very substantial one, and my lords have got that in the bundle. The most recent one, the IDC and Lenovo case, that was the better part of 4 weeks and involved extensive evidence, and judgment is awaited. So these are resource intensive for all of the parties involved in this case. And if my lords say, well, that's fine, we'll continue with that, then in some senses that's a matter for my lords. But my lords will appreciate that is a really crunchy, if I may put it like that, case management decision.
Well, it is, but it's in a sense giving both parties what they want. I beg your pardon.
I was just going to ask though, that just to be clear, this argument about case management stay only arises on the hypothesis that we uphold the decision.
Yes.
This court is clearly or distinctly the appropriate forum.
That depends upon the basis upon which you uphold it. So let us assume that your lordships uphold it on the basis that it is clearly and distinctly the most appropriate forum, because it is correctly characterized as involving a English patent dispute. So the primary basis upon, indeed the basis upon which the judge decided this case, namely the characterization basis. You will not have decided that this case is the most appropriate forum for the FRAND aspects, in the sense of the most appropriate forum to be deciding where the license should be determined. You will have been deciding this case on the basis that because it involves an English patent, there is no other forum in which these FRAND cases can be, this issue can be determined. And so you will not have been deciding at that point that the Chinese court is an inappropriate forum for a FRAND dispute on a global basis. Indeed, the Chinese...
I understand that, but what you're saying is that having determined that overall this court is the clearly or distinctly appropriate forum, we would then stay these proceedings for proceedings to take place in another forum, which it's your submission would effectively render these proceedings redundant. So it seems to me that there is an illogicality in that approach, because once we've decided that the whole claim, including the FRAND, is appropriately tried here, to grant a stay in favour of another jurisdiction would undermine that.
Well, no, it wouldn't. Because, with respect, the reason that it wouldn't would be because of the difference between time and place. So if in our submission, as for example the Chinese court has found in this case, the Chinese court regards itself as the appropriate forum to determine global FRAND terms, and my lords have seen that in the bundle, and that's a matter currently under appeal at Nokia's instigation. One would have essentially two courts that have decided that they were the appropriate forum for global terms. So there would be a clash in a sense of conflicts principles. In those circumstances, the point would still arise for this court as to whether, that being the case, this court should yield temporally to the Chinese court, or whether this court should say, well, no, I'm not going to yield temporally, I'm going to let these proceedings continue in their current form. So in our respectful submission, that doesn't decide the issue, although I can see why my lord raised the question, because you might say, well, there's only one question here, namely which is the appropriate forum for these matters.
It's plainly, I accept it's plainly a different question, but I think the oddity here is that it's not suggested that there is one part of the claim which might be tried first. What you're saying is the reality is there is only one issue here, in reality, which is global FRAND. Having heard that submission in relation to forum, your arguments only arise if we are against you in deciding that this is clearly and distinctly the appropriate forum. So I have some difficulty in seeing how the two things fit together.
It is right to say that the issue only arises if your lordships dismiss the appeal on forum non-convenience, because otherwise you would have granted a complete stay with respect to the matter.
Yes.
But in our submission, it still arises, and the case law indicates that it still arises, because even if a forum is a forum that is in principle can decide matters, it doesn't follow that it should decide a matter in advance of another forum. Let us take the example of an arbitration versus court.
It does with respect, because plainly the dispute arises in the context of the question is whether there is another an alternative forum, and the court has considered that and has considered that this one is the appropriate one.
Yes. Well, I mean, I think I can do no better than just to say that the issue of time and place are separate, and if the basis of the decision is that this is the appropriate forum because there is a patent in issue here, and that then brings with it the whole of the apparatus of FRAND into this jurisdiction, that doesn't decide the question of whether the apparatus of FRAND is actually most appropriately determined in one forum or another.
But the difference I see on that argument, the timing argument, is that proceeds on the assumption that one will then come back later to this jurisdiction to determine validity and infringement. And of course, if that happens, you then got the issue that, of course, if you succeed on validity and infringement, you need to bother with the Chinese proceedings at all. And in that case, that comes back against you the other way, doesn't it? In that you've had Chinese proceedings which you need never have had.
Well, no, because on that basis, the Chinese proceedings would have been of utility in any event. Because if one adopts the approach to which we have drawn attention in the case law, most recently in relation to in the Apple and Optus case, where the courts have recognised that it is right to give attention to the decisions of other courts. So, for example, what's described as local rate setting. It's a little bit artificial to describe China as a local rate. But the English courts could well say, well, whatever the position in relation to England, let's suppose the English courts were to go ahead, we are going to take in what the Chinese courts say is the appropriate rate for China in any event, because it would not be FRAND to do otherwise. The Chinese courts having said, the English courts having recognised at the outset, that it is appropriate to have different rates for China, which is something that was the starting point in Unwired Planet, recognised as well that it was appropriate to take into account what the Chinese courts said about their own rates. But then the English courts say, well, I'm not going to take that into account, would not be right in any event. So in our respectful submission, whatever the position, the Chinese court's decision is going to be of relevance to the English court, even if it is not absolutely determinative. Our primary submission is that it should be regarded as determinative, but our secondary submission is that even if it isn't determinative, it is certainly going to be of relevance and significance. And that's another reason why it makes sense for the English court proceedings to await the Chinese courts.
There'll be no relevance at all if the patent is found to be
invalid. Oh, my lord is absolutely right. If the patents are found to be invalid or not infringed, then well, in fact, my lord is right in some sense, but also not quite, because my clients have given an undertaking to respect the decision of the Chinese court as to rates. So it is right that the English court proceedings would be irrelevant, but the Chinese court proceedings in those circumstances, it's not just that they would be relevant, they would be determinative, because my clients and Nokia, if they bring in the cross-license in China, would respectively be paying in accordance with the judgment of the Chinese court. That would be the whole point, and in those circumstances, the decision of the English court on validity and infringement of these patents would itself be completely irrelevant if that was accepted by both parties. So, my lord, I recognise that I haven't quite yet finished the judgment. Is it convenient for me to spend 5 minutes on that at 2 o'clock?
Yes, 5 minutes, by all means. I just want to check one thing with you. The stay that you asked for was for a stay of everything.
Yes.
You didn't just say a stay of the FRAND. So this whole issue has been set up and decided by the judge and is now being argued on appeal as an all or nothing.
It is, although in fairness, the argument really relates to the FRAND matter. But
yes, but I know that this is always said it's really about this or it's really about that. But the court has got to deal with the application that is put before it, and the application that was put before it was an all or nothing.
My lord, yes.
You might have made an application simply to stay the FRAND element, but you didn't.
My lord, yes, and just by way of explanation, once one has, if an application to stay the FRAND matters is successful, then it might be said, well, really there is no point in having the further technical trials because the case is all about FRAND. My lord might say, well, you're saying what the case is all about, but the two go together in that if my lords are persuaded that the FRAND matters should be stayed, then the others ought as well, and conversely, if not, then not.
Right. Well, I just wanted to ask you about that. We'll resume for your last 5 minutes or so at 2 o'clock.